right, good afternoon, everybody, and welcome to the second installment of the McGuire-Woods COVID-19 Employment Webinar Series. Today we're going to be talking about employment challenges relating to the COVID-19 crisis. I am Rod Satterwhite, and with me is, well, not technically with me on the phone is my colleague Igor Babichenko. We appreciate everybody joining us, especially during what I know is a stressful and busy time for most of you, and hopefully we'll be able to pass on some information and guidance that you'll find to be a little bit helpful. Before we start, I've got a couple of housekeeping items I need to go over. First, if you will look at your webinar screen, you should see some kind of square buttons at the bottom of the screen, and there are a couple that I want to point out. The green one is a link to a copy of our presentation materials, and you will also get a copy by email after the webinar is over. The purple button is the Q&A button, and that will let you submit written questions to us during the seminar. We will leave time at the end to address the questions, but there's a good likelihood we won't be able to get to all of them. And if we can't get to your question, we'll follow up with you individually after the seminar. Next, we are recording this, and we will send you a link to the recording after the webinar is done, along with an evaluation, which we'd appreciate you completing if you have time. And then finally, for all the attorneys on the line, we have applied for CLE credit. We will apply it to the bar number that you provided at registration. If you didn't give us one, or if anybody has any other questions, please contact Laura Pickert at McGuire-Woods. Her contact information was on your registration email, and it will also be on the follow-up email that you get after we're done. So let's talk about the topic that has had many of us stuck in our basements for the last couple of weeks. We're going to deal with some employment challenges, and here's the way we decided to break this down. We're going to spend a little bit of time, and I mean a little bit, talking about OSHA and CDC workplace recommendations. A lot of this will be information that you've probably already heard in the media or seen in other places, but it's important to go over it from the standpoint of the guidance from these organizations because they have significant implications on ADA compliance, and that's the next topic that we're going to roll into. And then we'll talk about a couple of scenarios that we have seen, a couple of the more common scenarios, that is, in terms of requests and inquiries that we've gotten from clients and sort of how do you work through those. We'll do the second half covering wage and hour issues associated with teleworking. I read, I think it was yesterday, that literally 1/3 of the world's population is now under some kind of shelter-in-place or stay-at-home or closure order. So teleworking issues are obviously prominent and are probably prominent for many of you. And then we'll wrap up with some discussion of those shelter-in-place orders themselves and some workplace implications that they have. So starting with OSHA and CDC recommendations, and literally starting at the beginning, employers have a duty to maintain a safe workplace. That duty arises from the Occupational Safety and Health Act of 1970, and it's contained in this provision that's called the General Duty Clause. And it basically indicates that you've got to maintain a workplace that's free from recognized hazards that are either causing or likely to cause death or serious physical injury. And from this general standard, OSHA over the years has developed a host of extremely specific standards of how to maintain safe work environments. And that includes everything from how to put on a mask to when to wear a hard hat to how to lean a ladder up against the wall in a safe manner. Those standards cover a variety of different situations and a variety of different industries, but not this one. There is no real standard for dealing with the COVID crisis that we're dealing with now. So this general duty clause is kind of the catch-all, and that's what's got to be balanced against your other legal obligations as employers, such as the obligations under the ADA. OSHA has, however, issued a workplace guidance on COVID-19, and we'll give you the link to that if you haven't already seen it. The guidance makes it very clear that it is not an official OSHA standard or regulation and doesn't either create or change any legal obligations. However, it is highly relevant to the management of your employment environment on a day-to-day basis, not only because it contains good practical advice on preventing the spread of COVID, but also because other organizations like the EEOC, as we'll talk about in a bit, are going to look to why you do what you do in this environment. So if you engage in activities or take actions that somebody wants to challenge later as being a violation of some other law, such as the ADA, the Commission has stated that it's going to look at what you did with respect to OSHA and CDC and other types of guidance like this in order to determine whether what you did was acceptable. And so that's why I want to cover it briefly. In terms of the guidance itself, it's broken up into several areas. First, as you might expect, they want you to have a plan, and obviously if you're going to use it to show compliance with anything, a written plan is better. And you're all probably saying to me, Satterwhite, we're pretty much in the middle of this crisis. It's a little late for us to be drafting plans. And I understand that point, but I disagree with it slightly. I don't believe that it's too late to be developing a plan to deal with this situation if you don't already have one, because even though we're in the midst of it, you are going to be facing situations and scenarios that you have not yet faced. I mean, we are getting inquiries from clients left and right presenting us with new situations, which I know are presenting the clients with new situations that they just haven't thought about or haven't sat down and planned out. And so even a basic checklist, something in writing that identifies if we are faced with this scenario, what are we going to do, who's going to be responsible for what, and what are the next actions that we're going to take, can be potentially useful, not only from a practical standpoint, but also, again, from the point of being able to show that you were taking reasonable steps to try to follow this OSHA guidance. So the next category is what I call the low-hanging fruit, simply because we've all been inundated with this message for at least the last 2 to 3 weeks. We're talking about the basics of social distancing, hand washing, respiratory etiquette, and I'm not going to go through each one of these in any detail because, again, we've heard about them. The point is it just is a level of familiarity that you need to have and be able to show with the OSHA guidance in order to use that information at a later time. The next section of the OSHA guidance deals with how to handle sick individuals, and that starts with communication to employees, including what they should be doing for self-monitoring, what they should be doing if they exhibit symptoms, when they should report it, which is obviously immediately, and to whom they should be reporting it. So the communication is the first step with respect to healthy employees, and then the next step in the OSHA guidance is what to do with employees who show symptoms, and that's obviously getting them out of the office, getting them out of the facility, or getting them into some sort of isolated environment if removal is not immediately possible, and doing everything that's reasonable under the circumstances to keep them from infecting other employees. Now, this piece of it, the identifying and isolating sick individuals, does require some advanced planning if you want to be able to execute it properly. You've got to figure out who the individual or individuals in the workplace are those to whom the employees should report sick, whether that's going to be the individual supervisors or whether that's going to be somebody designated within the office. And you've got to think about where are these isolation areas going to be if we're going to implement them. And you've got to think about making those isolation areas at least reasonably compliant with your ADA confidentiality obligations, which we will talk about a little bit later. You don't want to be thinking about these things when you hear somebody coughing down the hall. You want to try to think about them in advance, and even though, like I said, we're in the midst of the problem right now, there is still time to put this together, and it will benefit you to do so. The next part of the OSHA guidance deals with leave policies, and this gets into a little bit more of an area where it will start to, I won't say conflict, but it will start to touch on some of your existing policies and practices. And you have to recognize that OSHA's goal in promulgating this guidance is literally single vision. It is to minimize the risk of infection. So some of these suggestions will make sense to you. Some of them will potentially conflict with some of your current practices. And part of what we want to try to do is at least get you focused on them and maybe give you some guidance on how to balance the two. The OSHA wants no punitive leave policies, which basically means if you've got somebody who's already burned through their sick leave and they tell you that they're not feeling well, you should send them home and you should not take any punitive action against them because your primary goal is to help prevent the spread of the virus. This next one is a little bit more controversial. The OSHA guidance suggests that you not require doctor's notes either on the front end or the back end of somebody taking leave because they exhibit COVID symptoms or because they've tested positive. And this may be a little counterintuitive to you. And again, the OSHA function is to minimize the risk of infection, and their reasoning behind this guidance is that you've already got a healthcare system that is terribly overwhelmed right now, and the last thing you want to do by requiring these doctor's notes is to further burden doctors with paperwork that is probably unnecessary. And I understand that some of you are probably saying, yeah, but I don't want to let a sick person back into the office. And there's no perfect answer to that, but I'll talk a little bit about the EEOC guidance at the end of my section, in which they do offer some alternatives. But just know that one of the issues from OSHA's perspective is let's not burden doctors more than they already are. OSHA also, in its guidance, breaks down jobs into various risk categories, and I'm not going to spend a lot of time on each one of these, but the reason that I want to commend it to you is because in its guidance, OSHA identifies additional steps that you can take with respect to each one of these categories. And the low-risk folks are the ones who have little or no coworker or public contact, and then it moves into individuals who are in high-density population workplaces like schools and travel industry, and then the high and the very high are generally healthcare workers, either those who are treating or working with suspected COVID patients, or the very high, those who are working with known COVID patients, and those are the ones who obviously require a little extra protection. And so the OSHA guidance gives you a pretty good overview of what should be done if you've got employees in those heightened categories. So I'm going to pivot over to the CDC. Again, the CDC has issued guidance for all employers. It is guidance. It does not, like the OSHA standard, it does not create or alter any specific legal obligations, but it is something that will be viewed as a backstop for employers who can demonstrate that they were taking reasonable steps to follow this guidance. Fortunately, it is consistent with OSHA, and there's a great deal of overlap here. They talk about sending people home. They talk about educating employees on ways to reduce the spread, the flexible workplace policies, and then one of the areas in which the CDC guidance is a little more robust is it discusses processes and procedures for enhanced cleaning and disinfection of the workplace, which the OSHA standard doesn't really touch on. The CDC guidance also contains some community-specific guidance, and so for those of you who have employees or facilities in some of the hotspots like New York and Seattle, there is some guidance that talks about other and more aggressive measures that you can take to help prevent the spread, including things like regular health checks to let people into the workplace and taking their temperature, which, again, I'll expand on in a little bit, and respiratory symptom screening. So that is the basic overview, and again, I would be shocked if there's anything in that overview that hasn't at least been floated on the news or floated in various meetings that you've been in. Here is a link, and again, you'll get copies of this if you don't already have them or choose not to download them, a link to those guidances from both OSHA and the CDC. Now, I want to change gears and talk a little bit about how all this impacts your existing obligations under the ADA. And we all hopefully know what they are. I mean, the general employer obligations here are you can't discriminate against individuals that have or are perceived as having a disability. You have to reasonably accommodate folks with a disability, and you have to maintain the confidentiality of their medical information. No big shocks there. All of this is unless there is a direct threat. Unless you can show that there is a direct threat, you have to follow these. You have to meet these obligations. And I will tell you, at the beginning of all this, we spent a great deal of time talking about what a direct threat was and whether this coronavirus was going to meet that level. I mean, the definition in the regulation is significant risk of substantial harm, either to the individual or to others, that you can't address with some sort of reasonable accommodation. And when this flu first became an issue, there was a question of whether it was going to be seasonal. There was a question of how widespread it would be, and lawyers in our firm, and I'm suspecting around the country, spent a great deal of time trying to analyze prior guidance to figure out whether the COVID virus was going to meet that standard. What we looked to was the EEOC pandemic guidance from 2009, which fortunately was just updated 6 days ago, and also fortunately has brought us a good deal of clarity over whether or not we need to consider the COVID virus to be a direct threat. The short answer is it is. And I'm sure after seeing everything that we've seen, nobody is terribly surprised by that, but it does make a big difference in terms of what kind of risks you take to comply with the OSHA standards and to comply with the CDC standards. So the position that the Commission has taken is that employers who are following advice from the CDC and other public health authorities on appropriate steps are not likely to be running afoul of the ADA and the Rehab Act. And for me, the key language in this provision is following advice from the CDC and other authorities and taking appropriate steps. So the point being, and this is the reason that we went over this at the beginning, if you can demonstrate down the road, if somebody challenges an action that you take under the ADA or otherwise, and if you can demonstrate down the road, hey, this is the guidance that I had from the CDC, this is the plan that I had, these are the steps that I tried to take to mitigate the spread of the virus, and I followed this in good faith, then you're going to have a very good chance of having a defense to whatever is being challenged. The EEOC guidance went farther and actually came right out and said the COVID-19 pandemic meets the direct threat standard. So this clarified a lot of what we were trying to dissect in the prior guidance when again, all this first started about 3 weeks ago. So what does that mean in terms of what actions you can take? Obviously, you can ask questions if somebody is experiencing symptoms of COVID. You can ask them about whether they've had a fever or chills. There might have been some hesitation about this previously as to whether or not this constituted a medical exam. That's pretty much off the table. So it's not a problem to make these inquiries, and obviously the symptoms are evolving and changing as they're learning more about the virus. I think a lack of a sense of smell and taste is now, I don't know if it's universally being added, but it's certainly being considered as another symptom. So as these are becoming recognized symptoms of the virus, it is fair game to ask employees questions about whether they're experiencing them. Taking temperatures is a little bit more controversial, as I mentioned, but again, the Commission has come out and given us some clear guidance. Given the community spread and given the fact that a fever is recognized as one of the primary symptoms of the virus, the EEOC has said in no uncertain terms, employer may take an employee's body temperature. Now, does the fact that you can take it impose any limitations on how you go about it? Yes. Just because you can take somebody's temperature doesn't mean you can cast aside, for example, your obligations to maintain confidentiality. And how does that play out? If you have, if you're going to take somebody's temperature to decide whether or not they're above or below the baseline for purposes of letting them come to work, then there's no need to write down the results of that. There's no need to write down what their temperature was. There's no need to create records there. Either they get in the door or they don't get in the door. And so you avoid a confidentiality issue by not creating a record of an employee's medical condition by not doing that. The other issue to think about there is if you're lining people up to get their temperature taken, what are you doing with people who are over the baseline? If some of the plans that I've seen involve having a sort of an isolation tent where you send somebody whose initial reading is over the baseline and give them an opportunity to come back and get retested a few minutes later, that invokes some sense of confidentiality issue. That creates a potential for people to see, hey, Bob got sent over to the isolation tent. He didn't get to go to work today. Maybe Bob's got a fever. Maybe Bob's got COVID. And I'm not saying there's a perfect solution here, but I am saying the fact that you're allowed to take an employee's temperature doesn't mean that you can ignore the confidentiality implications that go along with that. So the EEOC guidance also speaks to job applicants. You can ask them questions post-offer about whether they're experiencing COVID symptoms, whether you can also take their temperature. If they are symptomatic, you can delay their start date. And frankly, if you need somebody to start right away and they're symptomatic, you can withdraw the conditional job offer. All of that is explicitly laid out in the EEOC guidance. There's a more general reference in the guidance to the concept of undue hardship. You know, you've got to provide the reasonable accommodation unless you can show that it's an undue hardship. The Commission essentially recognizes that in these times, you're going to be tied up with a lot of other stuff. You're going to be tied up trying to deal with COVID issues, and you may not be able to consider or acknowledge or respond to requests for reasonable accommodation as quickly as you might not otherwise be. And so the Commission has recognized that, not necessarily in every situation, but that this delay may be constituted by an undue hardship in terms of dealing with the COVID crisis. Now, that doesn't mean that you can ignore accommodation obligations. So non-COVID related disability requests still there, and you still have to address them as best you can in the absence of that undue hardship, even though, again, your response may be delayed. So a couple of examples: if you've got an employee who's got vision issues and they use a screen reader in the office and you send everybody home to work from home, then you've got to at least consider providing them a screen reader at home. Another example is if you've got somebody with a heightened risk of contracting or being injured by the virus, and they say, I want to self-quarantine, then you may have to consider that as a reasonable accommodation and let them go home. And again, since we're sending people home left and right, there's probably going to be some difficulty claiming an undue hardship in response to that question, but it will depend on the circumstances. So the confidentiality obligation and the rules still apply. Medical information has to be maintained as confidential. And the area where this is a little tricky is when you do have somebody who identifies as having tested positive. Your first priority under the OSHA standards and under the CDC guidance, and I keep calling them OSHA standards even though I told you at the beginning they're not standards, I apologize. The OSHA guidance and the CDC guidance both indicate that you need to notify people with whom the positive test employee came in contact. So you have to do that while still limiting the disclosure of medical information. So you don't want to tell individuals, hey, Bob has just tested positive, you need to go self-quarantine because you had contact with Bob. You've got to do it without identifying Bob's name. And that's fine if it's a large workplace and there's a lot of employee contact, but if you're in an environment where there are 6 or 10 desks at a cubicle or cubicles in a room, and 5 of those are filled, and you've got one empty chair, and you tell the remaining employees, hey, you may have been exposed to somebody who tested positive, it doesn't take a rocket science to figure out that it was Bob. And again, this is one of those situations where there is no perfect answer, but if you made me choose, I would say you err on the side of safety here, because the tone and tenor of both the CDC guidelines and the tone and tenor of the EEOC updated guidance suggest that the emphasis needs to be placed on stopping the spread of the virus. And if you take reasonable steps by not naming Bob and doing everything you can to maintain his confidentiality, the fact that somebody may figure out it was him should not preclude you from notifying his fellow employees. And this is one of the, this is, I think, one of the most difficult areas in terms of dealing with the confidentiality, because once you tell people they may have been exposed, there are going to be questions, there are going to be rumors, there's going to be gossip. And I think the answer here is that you just have to take the reasonable steps that are available to you, but don't compromise the disclosure to potentially exposed employees. So I threw an optimistic slide in here. There is some guidance in the 2009 EEOC guidance about requiring employees to be vaccinated, and the guidance still holds today, even though we don't yet have a COVID vaccine. The short answer is you can't universally require employees to be vaccinated because there may be either disability-related or religious-related accommodations that you need to take into account. So the general guidance from the Commission is that you should encourage employees to get the vaccine rather than requiring it. But interestingly, in the 2020 update, they did only say, as of now, there is no COVID vaccine. They didn't say this still holds true. So I think there's a little signal here that they may change their guidance on the standard once there is a vaccine for COVID. All right, so all of that translated into specific scenarios that we've gotten multiple questions on from our clients. You've got an employee who's coughing at work. You've got an employee who comes to you and says, the guy sitting next to me is coughing and I'm concerned about it. What can you do? there is no question at this point that you can go approach that employee and start asking them questions about whether they are whether they're having symptoms or experiencing symptoms of COVID, and some of the possible inquiries, if they're coughing, are, how long have you had this? How severe has it been? Has it gotten worse? Are you experiencing any other symptoms? It wasn't that long ago where we would be very reluctant to tell employers to go start asking people questions about their medical condition, but now these inquiries are acceptable under the circumstances. And if you get, and it's reasonable to ask the questions. Bob may have had a drink of water that went down the wrong pipe, and somebody just overheard him coughing. So you want to exercise some common sense in these situations and not immediately throw on the mask and gloves and Tyvek suit and go running down the hall to talk to Bob. You need to ask some reasonable questions, and if there is any reasonable suggestion that he's got the symptoms, then it's perfectly fine to send him home. And both the Commission and the CDC Guidance have made that relatively clear. So taking it to the next level of severity, what happens if you find out that an employee has tested positive? And I tried very hard for everybody to come up with a clever acronym for the 4 steps that you want to take here. But the best I could do is that they're alliterative: isolate, investigate, communicate, and mitigate. I know it makes me sound like a boxing promoter, but in any event, these are the 4 steps that you want to take, both according to the CDC and OSHA guidance. And ordinarily, if somebody's testing positive or gets the results, they're already going to be home, hopefully not in the workplace. But if they are, you need to get them out right away or separate them right away. Then look into what other potential contact they've had, not just with other employees, but with customers, vendors, and with surfaces. What rooms have they been in? What surfaces would they be likely to have touched? Have they been working at the copier? That kind of thing. And that investigation will need to take place as quickly as possible. Next is communicate not only to other employees, and again, not identifying Bob by name, but other employees that they may have come in contact. And we've seen employers do that verbally, but we've also prepared documents, notices that can be provided to employees that are in writing that kind of document what happened. So that's something to consider. And then depending on the local requirements, you may have an obligation to report the diagnosis or the positive test result to the authorities. Mitigation involves cleaning, possible closure of the facility so it can have a deep clean or some combination of the two. And then the last scenario, again, we briefly touched on this, but you've got an employee who calls you up and says, I'm recovered, I'm ready to come back, and your question is, do you require them to go back to the doctor and get a return to work certificate? The answer is you still can. Nobody has indicated that that's prohibited. It's just that OSHA has correctly pointed out the practical impact on burdening the healthcare system even more, and the EEOC guidance mirrors that. It essentially says, you can do it, but you don't have to do it, and it adds to the burden on healthcare providers. But it does suggest some more creative alternatives, like whether or not the employee could be allowed to use just a local clinic, and whether or not you could accept something that's less formal than the ordinary note that you'd get from the doctor, like a form letter or some kind of a stamp, or even an email from the doctor that says, yeah, he's tested and he's clean. So, again, a lot of this is about striking a balance between maintaining a safe workplace and still complying with your obligations under existing employment laws. But thanks to the guidance that came out from the Commission about 6 days ago, I think we have a little bit more of a clear path than we did when all of this started. So I have gone over my allotted time, which I'm sure Igor will chastise me about. But at this point, I will flip it to him and let him talk about FLSA stuff.
Thank you very much, Rod. Good afternoon, and for some of you, good morning. The next topic that I am going to cover today is the Fair Labor Standards Act and also state wage and hour requirements and remote workers. Now, this is not something that's new. Work from home or telework has been becoming more popular in the last few years, especially as there's been increased connectivity. People can hold meetings with others across the country from their computer at home. But with COVID-19 raging throughout the country, telework is now on steroids. And the Department of Labor has issued guidance stating that an employer may encourage or require employees to telework as an infection control or prevention strategy. The CDC has made similar statements. OSHA has made similar statements, and later we're going to talk about state level and local level shelter-in-place orders, and a lot of them also specifically mention telework or work from home as an option, or some even stronger than an option to prevent the spread of the COVID-19 infection. So at this time, work from home arrangements are highly encouraged at the federal, state, and local level. Because this is not new, or at least the concept of work from home is not new, some employers already are used to such arrangements. They have the policies in place, they have the monitoring and mitigation efforts in place to prevent from getting caught into what I'll call work from home traps. But a lot of other employers, given the sudden onrush of the COVID-19 pandemic, have been rushed to adopt work from home with minimal notice and planning. And so what I want to do is cover some of the issues that we see pop up with work from home arrangements. Now, the first thing that I want to talk about is timekeeping challenges, and this is specifically relates to what are known as non-exempt employees under the Fair Labor Standards Act. Non-exempt employees are your hourly employees. They are entitled to at least minimum wage for each hour worked in a work week, and to overtime premium compensation at 1.5 times their regular rate for each hour worked in excess of 40 in a work week. Now, the FLSA has certain record-keeping requirements, among which is that every employer shall maintain and preserve payroll or other records containing hours worked each workday and total hours worked each work week. So somebody working from home, they still have to have a way of accurately recording and reporting their time, first, so that you could pay them properly, and two, so that you can comply with the record-keeping obligations under the FLSA. The other thing that comes into play are state meal and lunch break requirements. Some states, California, for example, require lunch breaks for non-exempt employees. In California, it's a 30-minute meal break for 5 hours of work, and then another 30-minute meal break for 10 hours of work. If somebody is working from home, they are still entitled under some states' laws to have those meal and lunch breaks. So again, the question is, how do you ensure that those requirements are being met when somebody or when a large part of your non-exempt workforce is working from home? And so there are a number of what I'll call mitigation measures that are easy to take and that can kind of head off some of these issues before they become real issues. And the first one I want to talk about is timekeeping policies. When non-exempt employees go to work from home, remind them in writing that the timekeeping policies that apply to them beforehand apply with the same force as before. Be clear that employees must record their time accurately, and they must record all hours worked accurately without exception. One way to do that is timekeeping software. Now, some companies, their timekeeping software, it's not a point of sale essentially. When you come to work, you clock in. Some of it you can do it on the computer, and that's one way to ensure accurate timekeeping. You still, when you log into your computer at home, clock in. When you log out for your meal break, clock out, and that's that ensures that non-exempt employees are still recording their time. Now, sometimes employers don't have that. So what do? There are a number of things you can do. One is require non-exempt employees to email their supervisor when they start work, when they take their meal break, when they return from the meal break, and when they are essentially done for the day. The key is daily and accurate recording of hours worked. The other thing that non-exempt employees should be required to do is to certify that their recorded hours are accurate. Now, this comes into play because with work from home, there are concerns about off-the-clock work. Now, The FLSA has a very broad definition of what it means to employ somebody, and it includes to suffer or permit to work. And what that essentially means is that if you allow somebody to work, those are hours worked. If you know or you have reason to know that somebody is working, you've suffered them to work. And so they've got to be paid properly for those hours. With a work from home arrangement, that's sometimes more difficult because there's no way to keep an eye on somebody when they are working from home. And so to limit any possible exposure for off-the-clock work, non-exempt employees should be required to certify that the hours that they are recording, whether through a computer application or through emails, are accurate. Because if they later claim, well, I worked off the clock, you can say, well, look, here's some evidence that you certify that everything that you recorded to us and everything that we paid you properly for was accurate. As I said, working off the clock can still be hours worked. That can lead to overtime violations. If somebody recorded working 40 hours, but they were responding to manager emails at 7:30 at night, those hours, quote unquote, off the clock would have taken them into overtime, and then you have a potential exposure for an FLSA overtime lawsuit. Now, there's some more mitigation techniques that I want to talk to you about regarding off-the-clock work and how you limit it. One is, encouraging a set or regular schedule. Employees who abided by a set schedule before the work-from-home arrangement should be expected to do so at home also. Now, it's possible that the nature of the job may not be the same in the office as it is from home, so where possible, you can involve employees in assessing whether their work-from-home schedule needs to change due to their new setting or circumstances. But once you have a set schedule, they hold employees accountable. Again, the circumstances to avoid are one in which an employee claims that the work-from-home setup meant that their workday became more nebulous and they were essentially working or on call at all different hours. So a kind of set schedule is a very good way to limit or even prevent off-the-clock work when somebody is working from home. Now, closely related to that is establishing boundaries between non-exempt employees working from home and supervisors. When somebody works from home, it can be easy to fall into a habit of informally communicating with that employee. For instance, sending an email saying this will only take a minute, or feel free to respond whenever you have a minute. These sorts of communications, if sent outside of an employee's normal working hours, can fuel off-the-clock work claims. So if somebody's established schedule is 9 a.m. to 5 p.m., managers shouldn't be sending emails at 5:30 p.m. stating, hey, feel free to respond whenever, because the employee might feel like they need to respond right then and there, spend 30 minutes, an hour, whatever, responding to the question, and then not reporting those hours worked and later claiming that they worked off the clock. And with work from home arrangements, you've got to be prepared to, address any problems effectively and efficiently. So if your, timekeeping function isn't working like it should, work quickly to address those gaps, whether it's through software enhancements or new procedures or protocols for reporting time or something else that makes sense to your business. If you're seeing, if supervisors are seeing issues that employees are emailing them or texting them off hours at 6:30 at night, 7:30 at night, they've got to be able to set those expectations. They've got to be able to communicate that we expect you to work from this time to this time, but if you are working past your established hours, you have got to record accurately all time worked. Again, that's the key, accurate and prompt recording of hours. Same issues with meal and rest breaks. If you're seeing that there's issues with that, address that with the employees, because these are proactive steps you can take to make sure that the compliance issues that can arise in work from home arrangements do not arise now that work from home is certainly a lot more common than it was before the COVID-19 outbreak. And so, one of the issues and a separate concept that you should be aware of is what FLSA regulations call waiting time. When employees are working from home as opposed to at an office environment, there can be an assumption that they're completely relieved of any duty to do work during down periods and can use that time for their own purposes, like, oh, hey, I'm not responding to anything right now. Let me go watch 10 minutes of my favorite show on Netflix, or let me read a book, or I've got 15 minutes here. Let me do some yoga. And the conception, or rather misconception, is because they've got these 15-minute kind of intervals and they're at home and they're doing personal things. That is not compensable time worked under the FLSA, and that's not the case. Even in an office environment, generally short breaks of 20 minutes or less is compensable time under federal regulations as well as many state wage and hour laws. So if you have somebody in the office that's taking a break and reading a book, well, they're still in the office working, and the same concept applies when you have a work from home arrangement. So in addition to the FLSA, there are state wage and hour requirements. And, in addition to lunch breaks and meal breaks, where this comes into play is work from home expenses. Work from home may result in increased costs for some non-exempt employees whose home environment is not set up to work remotely. And that includes, potentially increased internet speeds that are required beyond what the employer already has at home. Under the FLSA, you can't require an employee to pay back or reimburse for the employer's business expenses if doing so reduces the employee's pay below the minimum wage, which is currently $7.25 an hour. But more to the point, and this is going to come up more so than possible minimum wage violations, are state law requirements. There are states that say you cannot require an employee to incur business costs. You have to reimburse them. California has such a statute. Illinois has such a statute. New York and several other states do as well. So, as a general rule, if employees are going to incur work from home expenses beyond what they're already paying for their personal use, you've got to consider whether you will be required to reimburse those expenses. Now, most of what we covered deals with non-exempt employees, but there's also certain issues with exempt employees, and those are employees that are not entitled to overtime pay. They get paid their full salary in any work week in which they perform any work. And so what that means is if an employee worked 2 hours on Monday, office shut down because of COVID, and they were told to go home for the rest of the week, well, they get their salary for that full week because they performed work during the work week. There are only limited exceptions to that requirement. In other words, there are certain very limited circumstances where you can deduct for a day not worked, but such deductions are generally prohibited, and reductions in the predetermined salary will cause a loss of the exemption and trigger overtime requirements for the employee. Now, there is no requirement to pay salary in weeks in which the employee performs no work. So if an exempt employee doesn't work at all during a work week, there is no requirement to pay that employee. Exempt employees, even when they're working from home, still have to meet the duties test. And so there are a number of different federal exemptions from the FLSA: executive exemption, administrative exemption, professional exemption, and others that require certain duties that have to be the employee's primary duty to maintain the exemption. When an employee works from home, they still have to meet those duties tests to qualify for the exemption. Now, one question we've been getting a lot, especially with companies trying to cut costs, is can we reduce the salaries of exempt employees and say, hey, we'll cut your salary by 20%, but we only expect you to work for 4 days a week instead of 5, and you can work from home? The answer to that is generally yes, as long as it's for a bona fide business reason and not to evade the salary basis test of the FLSA. Now, if there is a across-the-board reduction in exempt employee salary, whatever that salary ends up still has to meet the minimum threshold required to maintain the exemption. And currently that's $684 per week or $35,568 per year. The Department of Labor came out with a brief question and answer guidance document on the FLSA and COVID-19, which you can find at that link. But again, the FLSA doesn't stop applying, or state wage and hour laws don't stop applying just because we're in a COVID-19 pandemic situation. The last topic that we want to cover with you today are shelter-in-place and business closure orders. It's a very kind of fluid topic because more and more states and more localities are adopting them. As of this morning, more than half of the states have either a shelter-in-place or a business closure order or some combination of the two. And they're largely the same. Shelter-in-place order requires residents to stay at home except for specific purposes. They can leave their homes to get groceries, healthcare, etc., and they can also leave their homes and travel to work for essential businesses. Now, what's an essential business differs from state to state and locality to locality that has adopted such an order, and that's why it's important to check on the specific order or orders that apply where your employees are. Business closure orders, again, similar concept. They're orders that require certain businesses to close or to limit operations. For example, restaurants that can't have dine-in anymore. They have to have only delivery or pickup, or limiting the hours that a business can remain open to the public. And generally, both shelter-in-place and business closure orders say that businesses that are allowed to remain in operation have to follow either CDC guidance, OSHA guidance, or make sure that they are practicing social distancing to the extent that's practicable under the circumstances. And you'll get the PowerPoint slide presentation. There are a couple of resources, including websites that have updates of state executive orders as well as local orders related to business closures or shelter in place. Now, again, each order is different. They're different in the way they define essential business, and they're different in the way that they restrict businesses from operating, but there's some common themes. Non-essential businesses, generally theaters, gyms, shopping malls, places of public gathering, while essential businesses are those that people will need to frequent during these times. Gas stations, grocery stores, convenience stores, pharmacies, some manufacturing. But again, it's important to check the specific order that applies in the jurisdiction where you have employees, because states do have broad authority to designate what is essential and non-essential, and these orders are constantly being refined and revised. So what may have been deemed essential under an executive order 2 days ago, that may have changed today. So if you do review the order and you decide that you are an essential business, we are allowed to remain open and we should remain open, the question is, how do we message that to employees? You've got to be able to justify why we are remaining open. And it's the same if a state agency comes knocking on your door to enforce a shelter-in-place order. There's got to be a justification for saying we are an essential business, we are allowed to remain open under this order, and these are the reasons why. Employment considerations, again, if you're going to stay open, most, if not all, of the shelter-in-place or business closure orders say that you've got to take proactive measures to ensure compliance with social distancing requirements. That means designating 6-foot distances or taping off certain areas where, members of the public can go see your product, but they have to stay within those taped off areas. And what Rod called low-hanging fruit, hand sanitizer, sanitizing products. Other ways are, separate operating hours for vulnerable populations. And again, some business can do online or remote access. You can order what we're selling online, and we'll have you pick it up curbside or at the store, or we'll deliver it to you. Just some things to consider when you do decide you are an essential business and continue operating. Now, the last kind of bit of information is, how long are these orders going to stay in place? And the answer is, we don't know. There's been some inconsistency or conflict between, the messaging from President Trump and the messaging from state governors and local officials. So this is another reason to keep an eye out on updates on your specific state or local shelter-in-place or business closure orders. Because ultimately, if President Trump wants to open up the economy and your governor says, no, we're not ready yet, we've got to keep these restrictions in place, those restrictions are going to apply. That brings me to the end of my presentation. I know I've seen some questions come up on the platform, but I'm going to turn it over to Rod to follow up on that.
Yeah, I'm going to try to go through and pick the easiest questions for me and the hardest questions for Igor. He didn't know that up front. The one thing I would add on the shelter-in-place orders, just to give you a concrete example, Washington State originally issued a shelter-in-place order that appeared to create an exemption for a fairly broad exemption for the construction industry. And then, I don't know if it was yesterday or day before yesterday, the governor issued a, quote, clarification indicating that most commercial and residential construction was non-essential and significantly narrowed the scope of that exemption. So, I mean, when we say these things are changing, they are literally changing day to day or within a 48-hour period, and changing in a way that creates a 180 reversal for certain clients who are in certain industries. So, tracking these things on the localities that your facilities are in or that your employees are in is absolutely critical for compliance. I'm going to tackle a couple of questions, give Igor a chance to catch his breath. Here's the first one. If an employee self-quarantines, do we require a doctor's note stating he or she is required to quarantine? How do we know as an employer that an employee is not simply taking advantage of the paid sick leave if there's nothing required from a medical provider? It's a fair question. I mean, and the short answer is you can still require the doctor's note if you want to. The OSHA guidance indicates that they don't want to overburden the healthcare system, but we all understand, and I mean, when we do employment law, we all understand that one of the factors to consider is the risk of abuse. And there is certainly a possibility that an employee would just say, I want to self-quarantine and have no real legitimate basis for doing it. I mean, one sort of less burdensome alternative would be to question the employee about whether or not they are experiencing symptoms. What is the basis for your desire to self-quarantine? Are you just afraid of COVID? Are you seeing symptoms? Have you been exposed to somebody who's got symptoms? And sort of drill down a little bit in a way that you might not have otherwise been able to when we weren't advising people that they could ask these medical type questions. And then, again, the only other caveat that I would place on that is if you do decide to require a doctor's note from employee A because you believe employee A is more likely to try to game the system, then you have a consistency problem if you have a trusted employee who also wants to self-quarantine and you don't require a doctor's note from employee B. That's disparate treatment, and of course we all know that it's easy to run afoul of discrimination laws if you start getting into the picking and choosing. And so the only other piece of the advice would be if you're going to do it for one, you need to do it for all. But I get the idea of people cheating, and I'm not suggesting that you abandon all methods of checking on people, but I am saying that the standards are a little bit relaxed at this point. Let's see.
I can tackle the next question. I mean, there was one asked about employer reimbursement obligations for working at home expenses. And the specific question was, do employers have reimbursement obligations to working at home employees for things like internet, electricity, heating, cell phone, landline, etc.? As I had mentioned, under the FLSA, you can't require employees, non-exempt employees, to pay work from home expenses that are for the business that would cause them to fall below the minimum wage. But the bigger question is state law requirements, and some state laws say that employees cannot be made to bear business expenses. They've got to be reimbursed for those. As a practical matter, if you're in one of those states, if you require an employee to work remotely who's not normally set up to do so, that's when you've got to consider the need for reimbursement for additional phone, internet, or other expenses incurred in order to enable that employee to telework, where such costs are incurred beyond what the employee otherwise pays for his or her personal services. So, assuming somebody working from home, they have the required internet access, they pay their own personal heating, they pay their own personal electricity, they pay their landline, and the business expenses do not cause them to incur any additional costs. Well, those are personal expenses, not business expenses, and so there is no reimbursement requirement, even under the state laws that require business expenses to be reimbursed when those are personal expenses. Rod, you want to tackle the next one if you've got one?
Yeah, we do. We've got a good one. If an employee previously tested positive for COVID and is now recovered, what determines if they are recovered, and are they required to get a follow-up test? I think my emphasis would be on whether or not they continue to pose a direct threat to others in the workplace. I wouldn't, and again, I'm certainly not a doctor, so I won't opine on what actually consists of being recovered, but as an employer, you want to focus on direct threat. So if you are going to require some sort of certification to allow them to come back to work, that certification ought to focus on whether or not they are contagious or in any other way do they pose a direct threat to the other employees in the workplace or potentially pose a direct threat to themselves. But I think the real risk that people are focused on is whether or not they could infect other people when they come back to work. So that's where I would draw the line on that standard. Let's see what else we got. We have a couple of questions on what do you do if an employee refuses to provide a note. And, it is certainly feasible to say if you don't provide the note, we're not going to allow you to self-quarantine. And this is in the context, I apologize. What if they refuse to provide a note in terms of self-quarantine is the first question. And under those circumstances, you can ratchet up the discipline because your policy probably requires somebody to provide a note if they're not going to be at work, and if they refuse to answer questions or provide the certification that you are requiring of everybody, then you can ratchet up the discipline under your policy. But I will say as a general rule, I think just as employers are getting a little bit more leeway these days in terms of taking actions that are focused on safety, I think if you get into a later dispute with an employee who can legitimately show that they were concerned or couldn't get a note from the doctor because the doctor was too busy, then you're not going to have a lot of sympathy. And so it's a little bit of a dodge question because it depends on the circumstances, but I think you've got to factor in the environment that you're dealing with here before you just tell an employee, well, if you're going to go home and self-quarantine and you're not going to answer my inquiries, then you're fired. I think that will be viewed potentially as an overreaction depending on the circumstances. All right, I'm going to repeat one question here that I don't know the answer to, but I will just put it out to the audience so that they're aware of it, and I will commit to getting an answer to the question because it's such a great question. It's worth at least repeating. If we have access to COVID-19 tests as a provider of critical infrastructure, can we require employees to take these tests? I confess, I don't know with any certainty the answer to the question. My instinct would be that it is at least going to be viewed to some degree as a medical exam, and whether or not you can engage in that medical exam will depend on the level of direct threat. And therefore, if an employee is not exhibiting any symptoms at all and you're not doing any kind of interim screening like temperature screening and you're going to make everybody do it, then that may be a little bit more difficult to defend than if you do it on, say, a basis of anybody who is exhibiting symptoms, we're going to require them to take the test, or anybody who's been around somebody who's exhibiting symptoms, we're going to require them to take the test. But I don't know that for sure, so I can't commit to it. But I think it's a great question, and it's worth us drilling down on. And we'll, again, for those who didn't catch it at the beginning, for the questions that we either couldn't answer or that we didn't get to, we will address those individually and figure out a way to publish the answers to those questions to everybody who's been in attendance. I think we are right at our time limit, so I don't know. Igor, were there any other burning ones that you want to try to tackle, or are we pretty good?
No, I think we can try to tackle any outstanding ones on an individual basis. We know what they are, and then we'll try to get back to everybody as quickly as we can.
And a reminder, this is recorded. You'll get a recording by mail, so feel free to share that with anybody that you think might be interested or just anybody who's having trouble falling asleep during their self-quarantine. Thanks very much for attending. We appreciate it. You all be healthy and stay safe.